Mezivolu T.Therieh, Principal District and Sessions Judge Kohima, to address us. She has been Registrar in the Supreme Court of India to look after the work of the Supreme Court Legal Services Committee and the Mediation and Conciliation Project Committee. She has worked for protecting every child's identity, be he or she figuring as an accused or as a victim of crime or as a witness. Madam, floor is all yours.
Thank you, Lordship, for the introduction. I have been asked not to address the gathering by name, so I will be avoiding that in order to save time. But Honorable Mr. Justice Suryakanth, Judge, Supreme Court of India, and Executive Chairman of the National Legal Services Authority, Lordship, thank you for granting me this opportunity and the privilege to speak today. Honorable Judges on the dais and off the dais, the Honorable Chief Justices and the High Court Judges, my colleagues from the District Judiciary, the officers of the National Legal Services Authority, and the State Legal Services Authorities, the speakers, esteemed guests, and ladies and gentlemen. It is a profound honor to address this distinguished gathering on an issue that strikes at the heart of human dignity and justice, the prevention of child marriage and the protection of child rights. Standing here today as a district judge from the state of Nagaland, I feel the weight of both our shared responsibility and our collective potential. Child marriage, as we all know, is not a relic of the past. It is a continuing challenge that silently robs millions of children of their childhood, their education, their health, and their right to self-determination. It is a practice that hides behind culture and neglect, but its consequences are grave and universal. In convening here in the city of Guwahati for this East Zone Regional Conference, we meet at a critical juncture. The northeastern and the eastern states together reflect the diversities of India's social fabric and also its most pressing responsibilities. From the tea gardens of Assam to the villages of Bihar, and from the plains of Bengal to the hills of Nagaland, the persistence of child marriage is both a social and a legal concern. Today, actually, my aim was to take us through the history, but since the former speakers have spoken about the legislative intervention and also at the international level, the evolution that has taken place, I will not be divulging again on those things, but briefly on the causes, the effects, and most importantly, to discuss what we members as judiciary can do to strengthen the protection of child rights. We are aware that India has made so much progress, yet the challenges remain immense. Nationally, there is a decline trend from 49.4% in 1993 to 22.3% in 2021 of women aged 20 to 24 who were married before 18, approximately 13 million girls, and the number remains alarming. Each day, roughly 4,400 child marriages occur across India, but only 3 cases on average are registered for legal action. This gap between crime and prosecution reveals the limits of enforcement and the persistence of social complicity. Within our East Zone, the picture is mixed. Women aged 20 to 24 who are married before 18, the statistics are from the National Health Family Survey, and for Assam, it is from the India Child Protection. West Bengal, 41.6%, Bihar, 40%, Jharkhand, we see a reduction from 37 to 32.2%. Assam, historically, it was high, but it is showing promising progress. So as reported by the India Child Protection, document an 81 percentile decline in reported child marriages across 20 surveyed villages between 2021 to 22 and 2023 to 24, with child marriages ending in 30% of surveyed villages and declining in another 40%. In Tripura, the rates remain around 40%. In Odisha, 20%, Arunachal 19%, Meghalaya 17%, Manipur 16%, Mizoram 8%, and Nagaland 5.6%. So these figures, it underscores 2 realities. First, child marriage is not confined to any one region. religion, or community. It is cutting across social malaise. Second, Northeast, despite better gender indicators in some states, is not immune. Even where the percentage is low, isolated clusters of high prevalence persist, demanding vigilance. The causes are like economic hardship, educational deprivation, caste and social inequalities, patriarchal norms, and weak enforcement. I would like to mention that our courts have long stood as the guardian of child rights and have been making interventions from time to time. Decisions of the courts have shifted the national conversation from punishment to prevention, from symbolic law to operational enforcement. We are aware of the Bal Viva Mukt Bharat, the Child Marriage Free India campaign, which was launched in November 2024. Its goal is to reduce child marriage prevalence below 5% by 2029 in high-burden states. So within months of this campaign, we have seen the official report says that there have been intervention and it prevented 35 marriages in Assam, 42 in Tripura, 6 in West Bengal, and 2 in Bihar. While modest in number, these are some of the successes that demonstrate how vigilant administration, empowered officers, and public awareness can save lives and futures. Under the Legal Services Authority Act, the national, state, and district legal services authorities are charged with ensuring that legal aid and awareness reach the most vulnerable. So there have been a lot of intervention and to prevent child marriage. So as in awareness and education, SLSAs and DLSAs conduct workshops in villages and schools to explain the PCMA, its penalties and right of children. As in empowering volunteers, the PLVs, the teachers and community leaders are trained to identify and report impending child marriages. Then the intervention and the legal aid, already as mentioned by our Honorable Justice Suryakant and also one of the speaker here, through the schemes like NALSA's ASHA, awareness, support, help and action, free legal aid is provided to the victims and or whistleblowers to file complaints, obtain injunctions or seek annulment. Then comes the coordination between the SLSAs and the DLSAs with the child marriage protection officers, then the child welfare committees and the Department of Education and Women and Child Development to ensure that rescued children are not left unsupported. And the socio-economic linkage like awareness of government schemes such as flagship welfare schemes of West Bengal's Kanyashri Prakalpa helps families see education as an asset and not a liability. The rehabilitation part, which has already been mentioned, so then even SLSAs help victims access shelter, counseling and vocational training. So these initiatives exemplify how the judiciary's outreach arm can translate law into real protection. Moving forward, our task is not merely to interpret the law, but to ensure its implementation in every district and village. The following steps provide a practical framework for collaboration. Firstly, village-level monitoring committees. Each district can initiate committees, including local officials, school heads, ASHA or Angawadi workers, and youth leaders to monitor and report suspected child marriages. Linking this committee digitally to district child protection units can enable real-time response. Second, state-specific SOPs. Already it has been mentioned, but every state should adopt an SOP for preventing and responding to child marriages, defining roles, timelines, and accountability. The courts and the SLSAs, the DLSAs can encourage state government to formulate these SOPs, drawing on models used for child care rehabilitation. Number 3, empowerment of child marriage protection officers. Judges should ensure CMPOs are known, trained, and active. Directions can be issued for quarterly performance reports, and magistrates should swiftly on CMPOs applications for injunction take steps. Number 4, fast-track and child-friendly courts. High courts can designate or strengthen fast-track and child-friendly courts for PCMA or POCSO matters. Then the partnership with youth platforms. Initiatives like Odisha's Advika clubs, which have mobilized 2.5 million adolescents and trained 3 lakhs peer leaders prove that peer influence is transformative. Judicial officers and DLSAs can support such clubs through legal literacy sessions and mentorship. Number 6, mass awareness and report mechanisms. Use every medium like radio, like folk theatres, social media to spread message of child marriage-free India and encourage community to use helplines 1098 and online portals to report cases. 7, education as prevention. Schools must be enlisted as sentinels. DLSAs can coordinate with education department to track female dropout rates and investigate abrupt withdrawals. As judges, we can advocate inclusion of comprehensive life skills and reproductive health education to equip adolescents with awareness and confidence. Then the comprehensive sex education, coupled with gender sensitivity training, prepares both girls and boys to make informed life choices. As one student author insightfully wrote, sex education must go beyond biology. It must teach respect, responsibility, and autonomy. School-based legal literacy drives and parental workshops can bridge this gap. Finally, number 8, family and community counseling. Courts may direct counseling for families found attempting child marriages. Religious and community leaders should be partners, publicly refusing to solemnize underage unions, publicly denouncing child marriage, shifting social acceptance into social disapproval. Then NGOs and civil societies can bring creative and cultural intervention. Families too must be partners in reform. When they are made aware of the legal risk, health dangers, and social alternatives, their choices can change. So these are the 8 pillars for monitoring, procedure, empowerment, fast-track, youth engagement, awareness, education, and counseling. And together it can form a robust framework for eradication of this practice in our lifetime. Honorable dignitaries, when we speak of child marriage, we are not dealing with numbers. We are dealing with lives, with futures. Behind every statistic is a girl who might have become a graphic designer, a journalist, a beautician, a teacher, a nurse, or a judge herself, had she not been denied her right to childhood. As judges, we wield the moral and legal authority to make difference, not only through our judgment, but through our leadership in the community. So I would like to leave with this statement that every suo motu action that prevents a child marriage, every directive that strengthens enforcement, and every awareness camp we support sends a powerful message that law stands with the child. Thank you for this time.